Hello, everyone. It's Anthony Bandiero here with Blue to Gold Law Enforcement Training, bringing you to the Roadside Chat. All right. So our question today comes from an officer in the great state of Tennessee. Love Tennessee. All right. So here's the question. Can a tenant in a government housing project waive their Fourth Amendment protections of the home by lease agreement? Okay. Let me give some context. So the officer is sharing here that in our local housing authority, it is my understanding that the manager can enter and search a tenant's apartment anytime under their lease agreement. On occasion, they have asked that we stand by while they do so, and have even asked for canine to sniff the apartment. Does this violate the Fourth Amendment, or does the lease agreement act as consent? All right. So the quick answer is, can the government housing project waive a person's Fourth Amendment rights? And the answer is no, because no government agency can basically tell a person, you have no more Fourth Amendment rights, right? If you're going to subscribe to this or, accept these government benefits, you have no Fourth Amendment rights. That's not the way to look at it. Instead, the question is, okay, are they asking for something that is reasonable, right? And if it's reasonable, it likely complies with the Fourth Amendment. It's not like the government housing projects have no authority to inspect their property, to make sure that people are not abusing the property, and if they get a tip that somebody's manufacturing drugs or so forth, that they can't do anything about it. But the point is still, is that a waiver of the Fourth Amendment? No. Is it potentially reasonable under the Fourth Amendment? Maybe. So let's go through it. So number one, apparently, right, or allegedly, the lease agreement says that we can come into your apartment at any time and inspect. I doubt that's the case, right? If it truly said that we can come into your apartment at any time and, without notice or without any kind of just cause, I doubt a court would uphold that, because that is not reasonable, right? You are the government, and you're offering these benefits, and you're saying, as a stipulation to accepting the benefit, I have to allow the government, right, aka the housing authority, allow the government to come into my home and just rummage through my stuff or just inspect my property? No. So I doubt that that's the case. More likely, the contract or the lease agreement says something about some cause, right? There's some item that may be causing damage, like a water leak, or we have reason to believe that that there's additional people living in the home that are not allowed to be there. Maybe if it's an emergency, no notice. If it's a non-emergency, maybe some notice. But all those things are going to be hashed out by legal counsel representing the government housing project. So as a cop, whatever that says is probably legit because it's been researched. So I'm assuming, without even seeing it, that the lease agreement has some clause in there that either it's for emergencies or for cause. Let's go on to the next question. Okay. Can the cop sniff the door of the apartment? Well, generally speaking, the answer is yes in most courts. Some states don't like it, like Connecticut and Texas and so forth. Some states are, fully on board with allowing it because there's no privacy interest. The Supreme Court has only addressed sniffing a door with a drug canine at a home where the outside was curtilage. They have that case that case, by the way, is Florida versus Jardines. That Jardines case does not apply to apartments where the door is situated in a common hallway, because that common hallway is not curtilage. So curtilage requires a right of exclusion, right? Usually, like, you can exclude other people. Well, if it's a hallway, there's no right of exclusion. Now, certainly in some apartment layouts, there may be some property or piece of, hallway that is really just for that occupant. Nobody else should be there except the occupant. And if that's the case, buyer beware. You should not be doing any kind of criminal investigation activity except a knock and talk or some kind of emergency response and so forth on that piece of property if it's really just for that particular apartment and nobody else should be there. It's kind of like their little piece of property. It's kind of rare, but those situations do occur, right? But generally speaking, most courts have found that a canine sniff of an apartment door in a common hallway is not a search under the Fourth Amendment. And they certainly have found that to be the case of a hotel and motel apartments or rooms. And again, it gets a little tricky with apartments. But generally speaking, to answer your question, not a search under most courts. I also believe that the U.S. Supreme Court would if they had the opportunity to address this issue head on, I think they would find the same thing, because all of the curtilage laws and so forth in the prior cases are in the line of no search, right? There's no privacy expectation in the hallway, so therefore the dog can be there. Now, if the apartment is closed, the apartment corridors are locked, and there's only permitted access with a key card or something like that, then the cops would have to be in there lawfully first before deploying the dog. That's what I would suggest. Next, can the manager, right, of the government housing project ask police to stand by while they do these searches? Well, certainly police are allowed to be where they're allowed to be. So if the manager wants them to stand out in the hallway and just stand by for any kind of safety issue, there's no Fourth Amendment issue that I can see there, right? The cops are not telling the manager, hey, go search that house. Hey, we have a tip that there's a drug lab in there. Can you go in there under your independent power? They're not doing that. They're just standing by for safety reasons. That does not even implicate the Fourth Amendment in my book. All right. So I'm just trying to make sure I got all these questions, right? The one thing it hasn't been specifically stated here, but one thing I'll share with you is that let's assume that the manager is inside the apartment for some lawful reason, right? It's per the contract. It's to investigate some kind of damage to the property, a tip that there's unapproved people living at the apartment, drug lab, whatever. And the manager can get in there under lease agreement. Can he or she invite police to go along with them? And the answer is probably not. Right now, if there's a safety issue, that's totally different, right? We can restore order and maintain order, but we don't want police inside apartments, generally speaking, because even though the contract would allow the manager to go in there, same as a hotel room, like housekeeping, managers, and so forth, even though they can go in there, it doesn't mean police are also allowed to tag along, unless there's a legitimate safety issue or some kind of ongoing criminal issue going on, right? Where there's some kind of safety, exigency, destruction of evidence, and so forth. I hope it helps. It's a little off the beaten track, but what I normally teach, because this doesn't come up too often with my experience with these government housing issues, at least in where I'm teaching. But I hope it helps. Keep the questions coming. If you want to submit another question, go to bluetogold.com/show. And until next time, guys, keep doing the great job you're doing.
When it comes to law enforcement training, we are the gold standard. Visit bluetogold.com or call 888-579-7796 to learn more about our training, books, and free webinars. Also, don't forget to like, subscribe, and share this channel.